benefit of following a case in a small community is that you don't have to guess too hard about who is going to be involved in the case. So we're going to take a look at who is going to be one of the most influential figures in the Idaho 4 murders case, and that's the judge. In this particular case, it's pretty easy to anticipate who the presiding judge is going to be because there's only really one option. The way that Idaho's court system is set up, they have what are called district courts that handle their felony criminal matters. And so district judges are the judges who are empowered to hear and decide everything in those types of cases. Idaho also has magistrates. These would be kind of equivalent to magistrates in U.S. district courts, or like misdemeanor judges in counties that have separate misdemeanor and felony courts. Magistrates do have some limited authority to decide kind of preliminary issues in felony cases. One example is that magistrates can handle the first appearance. So it's possible that Mr. Kohberger's first court appearance is not going to be handled by the presiding district judge. It's possible that that could be before a magistrate. But for all of the critical substantive decisions that are going to be worked out as this case makes its way through the legal process, the overwhelming majority of those decisions will need to be made by the district judge. And so in this particular case, our district judge is a gentleman named John C. Judge. And you heard me correctly. I don't know if he was born for this moment or if this is just one of those remarkable coincidences that just sometimes happens in life. But Judge is the one who drew the short straw and is going to be in charge of handling this case. So I wanted to take a look at him and see what we could find out based on his record, his background, any type of information that's easily available to get a sense of how he might be expected to conduct himself in this particular trial. So I'm going to share with you some of the things that I found. Given the magnitude and profile of this case, I was very eager to find out mainly what kind of experience does this judge have. So I was able to learn that he has been on the district court bench since 2018. That's not a super long time to be a district judge. However, he was a magistrate since 2008. Before that, I was able to find this news article from the time of his appointment to district court. And that indicates he'd been in private practice for 24 years before being appointed as a magistrate, and enjoyed what appears to be a stellar reputation in his local community at the time of his appointment to district court. So while he, isn't going to have all of the criminal experience in the world going into this trial, nevertheless, he's got enough here to indicate to me a pretty solid background in at least the basic issues. He's not going to need to be educated on the process or anything like that. So that is something of a relief to see that we do have a judge who is not green. He's not going to be dealing with the additional stress of trying to navigate an extremely novel type of case in the glare of the public spotlight that this case is almost certainly going to get. In addition to his experience with criminal cases from all of his time on the bench, I was also able to learn that Judge himself did some criminal defense work in private practice. And I found this out because he's on record as counsel in a couple of appellate cases that went up for decisions. So there was one in 1989 that was kind of a generic appeal that he lost. I don't hold that against him at all because that's most of the time what happens with criminal appeals. But he also had a fairly significant decision in 2006 from the Idaho Court of Appeals that he won. and got a published opinion out of it. And so in that particular case, he had argued that his client had ostensibly consented to a warrantless search, but that his consent was not voluntary under the circumstances present in that case. So he made that argument and he won it, which quite frankly is not an easy argument to make from my perspective. So I find this a very heartening type of situation because it does tell me that criminal process, criminal issues, these are not new to him. And he is not just showing up to kind of check the box and, convince his client to plead guilty and be on his way. He's actually filed the motions and done the litigation, done the research, done the work that goes into being able to identify what are the issues here, what's the legal framework that we're operating within. I realize that may not sound like a very high bar, but it's kind of just the reality that probably the most of the criminal cases that go to court don't get a lot of litigation involved with them. So the fact that he has done that, he has been involved with that, suggests to me he had a relatively high-level criminal practice that gave him familiarity with the legal context he's going to need to be navigating in this case. So it's good news that Judge does have some of a background in criminal law, criminal practice. He's not just a civil lawyer who ended up on the bench and is going to have to be figuring all this out in the context of this case. That would be a nightmare. But having said that, Moscow, Idaho is a very small community. They don't have a lot of homicides. Most crimes go to the public defender anyway. So it's extremely unlikely that he has personal experience with these types of severe felonies and certainly a capital murder. It's virtually certain that he, didn't handle a capital case as an attorney, may not have handled serious felony cases at all. So that means he's going to be relying on his experience and his skills as a judge to be able to navigate the kinds of problems he's going to be faced with as this case unfolds. So we can get a little bit of a sense of how he operates as a judge by looking at the record of decisions that he's made as a judge that have gone up for review. And from that, we can see, is he frequently reversed? Is he frequently affirmed? What types of decisions get appealed? And that kind of thing. So let's take a look at his judicial record. You might expect the judge in a small, rural, agricultural community to be a hanging judge, to be a prosecutor on the bench. And that is often the case. I've spent the overwhelming majority of my career working in small counties, and that is sometimes the case. There's a lot of political reasons why that can be, but the important thing here is that it does not look at all to me like that is what we're dealing with Judge. When you see a classic hanging judge, what you typically see is somebody who simply uniformly rules in favor of the prosecution. And so as a result, they will frequently have a fairly high rate of getting overturned on appeal. They simply aren't friendly to the defense arguments. They aren't willing to, do the research. They just give the benefit of the doubt to the prosecutor, whatever. And so that type of judge is typically going to be able to be identified by a lot of pro-state rulings that have to go up for review and get reversed. So Judge does not have that type of record at all. His record is, again, it's pretty limited in part because while he spent the 10 years as a magistrate judge, misdemeanor cases don't get appealed to this level very often. So he doesn't have a big record of decision-making as a magistrate that made it up to these levels of review where you can have these, decisions that you can read and see what they're based on and stuff. But what he did do does seem very inconsistent with this stereotypical image of the hanging judge. First off, he was willing to make pro-defense or defense-friendly types of rulings. He would grant motions to suppress. This I'm pointing out not because like I'm cheerleading for defense rulings or anything like that, but just because it, from my perspective, is an indicative of somebody who is fair, who isn't going to just ignore an argument because it happens to be coming out of the defense attorney's mouth rather than the prosecutor's mouth. This is a very good sign that what we're dealing with here is somebody who does care about the law, looks at it, respects it, and does his best to interpret it and apply it the way it's intended to be applied. So in terms of a judicial skill that he's going to need to have for the issues that are going to come up in a capital murder case, he does seem to be temperamentally well-equipped for the job. Another reason why this record matters is because it reinforces the likelihood that Judge is going to be the judge on this case. Now, I said at the very beginning, there's only one in the county, so we can be pretty sure it's going to be him. But at the same time, Idaho does allow criminal defendants to disqualify a judge. They have a process for that, and you don't require a reason. You don't have to have a justification for it under this process. As long as you make your request within the time that's required, you're allowed to disqualify one judge in a case for no reason at all. So that's the type of thing that you might do if you draw that hanging judge who you can already anticipate is going to make you really litigate your case on appeal rather than at trial. But when you land somebody like a judge who has the record that substantiates him as somebody who is going to be willing to entertain defense arguments, who will apply the law, whether it benefits the defendant or not, that's the guy that you want. That's the guy that you're hunting for. So it's far less likely that you're going to use this disqualification to strike somebody like a judge, because you're rolling the dice on potentially getting that hanging judge as his substitute. So because of this, it's just one of the many reasons why his temperament, I think, is likely to be a very good fit for this particular case, because he is going to present as a judge who is fair and who is going to give Mr. Kohberger a fair chance at being able to try his case. The last bit of background I was able to find about Judge is that he is the administrative judge for the 2nd District in Idaho. If you followed the Depp versus Heard trial, you will remember that both Judges White and Judge Azcarate were the chief judge of the Fairfax County Circuit Court. And so this is a similar type of position. It's just that it involves multiple courts kind of grouped together as a single administrative unit. And so the role of the administrative judge is typically going to be to deal with the business side of operating a court. There have to be assignments. There have to be decisions made about HR policies and information technology. And there have to be decisions made about vacations and docket coverage and when to adopt court rules. I mean, just kind of constant business of a court that goes above and beyond just handling cases in front of you. So that is the role that he has here. Under the rules for the 2nd Judicial District, that position is chosen by the judges in that district. So he was selected by his peers, basically, to be the administrative judge. What it tells me is a couple things. Being the administrative judge is a thankless job. It is not something that you do because you get a lot of perks and a lot of upsides. It's typically a lot of work, and you often annoy people. It's thankless, and nobody really wants to do it because you don't get a lot of upside for it. So it's a service-oriented type of role. Suggests very strongly to me that this judge has a service-oriented mindset. He's willing to take on this type of responsibility because somebody has to do it, and it should be done well. This is also consistent with the comment that was presented in the article from back when he was appointed as a district judge, that he enjoyed basically a lot of esteem, a lot of respect from his peers. So we see that continuing to be the case. Even in this short time that he has been on the bench, he has earned enough of the respect of his colleagues that they have entrusted him with this leadership position. So that does speak very well of him as somebody who is a leader in the local legal community, and has earned a lot of respect from the people that regularly practice and appear there. Overall, this research left me with a very positive view of Judge Judge, and I'm really optimistic about his role in the case. I predict that he is going to be somebody who is very even-tempered, who is going to be prepared to manage the problems that arise in the case. I don't expect him to decide things quickly. I expect him to be thoughtful and considered, because overall, I believe his goal is going to be to do this right for the sake of the process, for the sake of Mr. Kohberger, for the sake of the Moscow community that is relying on this process to establish what happened on the night of November the 13th and whether it is Mr. Kohberger who was responsible for causing those deaths. I don't think he wants to see this case come back. I don't think he wants to see this case become an enormous burden on his community. And so I think that he is likely to be very careful and very prudent in his decision making. And when you have a case of this type of significance, that's really the most that you can ask for from a judge, is that he gives it the best shot for the jury's decision to be the final say in the case. So we'll hopefully be getting to know him in the coming days as court appearances begin to take place and we start to get to see him and how he operates as a judge. I'll be watching and letting you know what I find, so do stay tuned, and I'll see you in the next one.